Okay, good afternoon, and welcome to episode 10 of Ask Judge Carol Live, where we take the law from the courtroom to your living room. If you are here with me live today, please say hello in the chat so that I can see who is here with me. And also, of course, drop your questions in the chat and I will get to as many as I can as we go along. Today's topic is on generational property. And we are going to have a discussion about what that is. How do you know if you have it, if you have an interest? And we are going to also look at a case where there was a competition between relatives as to who were the owners of the land. So, first of all, what is generation property? Generation property or generation land is land that has passed down through several generations of the same family, often without the ownership ever formally being transferred by some kind of deed or through the estate being administered in the probate courts. Now, if you follow me, if you're going to be following me, that is a term that by now you should be familiar with. That is the term quote unquote administration, where an application is made to the court when a relative, when a family member has died, for a personal representative to be appointed. And then that person, in the eyes of the law, stands in the shoes of the person who is deceased, and they then issue a deed, they issue property, a conveyance or a deed for the title to go from the body, as it were, of the deceased person into the hands of the surviving relatives. And that conveyance by the personal representative is done based upon either the terms of the will, where the deceased person stated who was to inherit from them, or under the laws of intestacy under the Inheritance Act. But if that hasn't been done, then successive generations of heirs become entitled, and that's how the pool grows and grows and grows and grows. So, and we're going to look a little bit more about that. So, generation land is land that has been in the family for generations. So, your parents, grandparents, great-grandparents, great-great-grandparents. And everybody owns a piece of it or assumes they own a piece of it because my granddaddy, my great-granddaddy, and so on owned that land. And so you know that as one of their children or great-grandchildren, you would have an interest in the property. And so one of the things that it's useful to point out here is living on the land does not necessarily mean you own the land. Even if you're a relative, you may own a portion, you may have an interest in the land in terms of, you have a share, but just because you live there and there are other relatives, you have cousins, other siblings, they too may have an interest in the land. So living there alone when I say alone, living there by itself, in and of itself, doesn't make you become an owner of your granddaddy's land or your Grammy's land. Cutting the grass doesn't make you an owner. Planting fruit trees doesn't necessarily make you an owner. Even putting a fence on the property, as we're going to see in the case that we're going to discuss today, building a house, those things don't automatically make you an owner of generational property. So they will be important evidence, but they do not automatically give you title. So as I said already, usually through a will or through intestacy or a conveyance, that's how you will know that you are an owner and how much of the property, the generation land, is yours. So And also, so I mentioned cutting grass, planting fruit trees, and so on. Also, just because your daddy said so or your Grammy said so, just because they told you that, also, that doesn't equate to you becoming an owner. All right. So, and this is why, we have these disputes because, for example, a cousin builds a house, another one moves overseas, and then 20 or 30 years later, one of the relatives wants to sell. And you're thinking, well, my cousin moved or my brother moved away 20 years ago. They never came here. And maybe you weren't living on the property either. And now you would like to sell it. You have an interested purchaser. So if a developer is interested, or you want to do a develop, or you yourself want to develop it, and then the bank requires clear title, these are things that are going to cause an investigation into title to have to be made, and then you have to go back and see when was the last time that the property was probated and who were all of the descendants of the person who you can trace the last paper title to. Okay, so we're going to talk today about the case of Miklwhite, Rochelle Miklwhite, and Florence Sands, Felicia Bethel, Albertha Culmer, a case from Eleuthera, Governor's Harbor, Eleuthera. Now, the petitioner in that case was David Billy Miklwhite, and he says that he lived on the property from about the 1960s, and although there was some dispute on the evidence of that, because on the one hand, I think in one place he said he was there from the 60s, and then in another place he said he was there from the about the 70s. So, so we are going to, I'm just finding the relevant facts of the case. Okay, here we go. The petitioner and the adverse claimant. So the petitioner was David Billy Miklwhite, and then he died, and his daughter took over the case as his executrix. So you have David and then his daughter, Rochelle Miklwhite, and the adverse claimants were relatives of theirs. That would have been Sands and Albertha Sands, and I'll get the name in a moment. So they were adverse, they were blood relatives, and the petitioner, who was David Billy Miklwhite, he brought a quieting action to quiet the 37 acres of land that he says his grandfather had left. And I think it was the grandfather and then his great-grandmother who died. And there was a probate for that estate that went back to 1955. And so he alleges, this is David, he alleges that sometime in the 70s, he and his mother entered into possession and began farming thereon. However, his mother died in 1981. So that would have been just about 11 years. Now, it doesn't indicate where he was after that. It appears that he was still living in Eleuthera, but he wasn't physically in occupation of the whole 37 acres of the land. But there was that he was dealing with. He would give other people, certain people, that is, permission to use a portion of the land for dumping, and he fenced in a portion of it. He allowed persons to excavate quarry from the land for the payment of a fee. And then there was also a portion of the land that he closed in with a chain link fence. Now, the petitioner's daughter confirmed that he put up a fence and it had a lock, and she kept a key for the property. So if anyone wanted to go there, if they were giving anyone permission to dump on the land, they would have to come to her, they would have to pay, and they would have to get a key. So they were able to show, in relation to at least a portion of the land, that they had the occupation of it. So he was claiming that, David now is claiming that based on those acts of possession, oh, hi, Sherez. Good to have you here. So he's claiming that based on those acts of possession, he was entitled to the entire portion of land. And the adverse claimants, so they were also his relatives, descended from the same person, who was Alice Maud Charles, and there was a grant of probate into her estate back in 1955. But then no other relative, as you could imagine, between 2014 when this action was brought, or 2011, and 1955, there would have been a number of descendants, a number of relatives who would have died, who would have had an interest, but it does not appear that any of their estates were probated, which means that no title documents were ever issued in the property to any of the respective descendants. And the adverse claimants also claimed documentary title through the same Alice Maud Charles, and through her estate. So the main thing to note here with this case is that, so as I mentioned, relatives both claiming the property really through the same ultimate ancestor, and both claiming some kind of possession. What ended up happening in the case is that the court found that David's possession was not sufficient and was not of a nature that he could exclude the adverse claimants. In fact, he had conversations with his relative, and really acknowledged when he was trying to get the property sold that they needed to agree. And he said, we have to work together so we can get the property sold, so they could both realize some benefit from it. And that was taken by the court to be really an admission against his interest. So what the court looks for, if you are claiming that you are the owner of property and you don't have a paper title, then they want to see that you have possessed it, you have physical possession, and that your physical possession is to the exclusion of anyone else who might have an interest. They may have a paper title, or they may have an entitlement based on documents. But if your possession is such that you block them basically from using the property, and you show an intention by the way that you possess the land to exclude anyone else who might have an interest, then that is something that the court would consider as allowing you, or not necessarily allowing you, but demonstrating, I think is a better word, demonstrating that you have excluded someone who claims to have a better title than you do. So fundamentally, the law of the Bahamas is that there's really no such thing as an absolute title. It's more a question of who has a better claim, who has a better title. And you can demonstrate that either through possession and documents, or just simply from possession, and what we call adverse possession. So in this case with David Miklwhite, he had some possession, but he was only on the 37 acres. He was only in a small area of it that he used to control, and he also made certain statements and behaved in a way that showed that he acknowledged that he was not the sole owner. So that was basically what we would consider he was demonstrating a conflict of his own interest. Whereas in another case, and other cases where there was a son who initially in 1962, the father put his wife and children onto the property. This was in an area in Engliston. He put them on the property, and then off he went. And his mom and the children stayed on the property. He stayed there through to manhood, and his father came. So the father, I think, came once to visit the property, and his then ex-wife chased him away. Like, where you going? You have no rights to be here. The mom eventually moved out into accommodation with her other children, and this son continued to live on the property. And he put up a wall, he put up a fence, he established a business and stayed there. And then, so 30 years later, when the father came and brought someone to the property purporting to sell it to this owner, thinking, well, I bought this property, I have a mortgage from the bank, I'm now selling it to person A over here. The court said, no, no, no. You left, your son has been in occupation of this property all of this time, and to the exclusion of you and everyone else. So even as against his own father, the son was said to be the owner of the property, even though his dad had the paper title, because he lived there to the exclusion of anyone else, even after his mother left, and clearly behaved in a way to treat the property as his own. So his dad came with a paper that was literally just a paper and said, I own this. And the court said no. Actually, it wasn't the father who came. It was the couple that bought the title from the father, because they would have, done a title search and it would have looked clean on paper, which is why, as I've said to you in another episode, when you're buying property, the buyer must take care, and you should go and view the property. Although they did view the property, but they seemed to think that because it was the man's son, that it didn't matter, but they were out of luck. So the nature of your occupation is important. Your intention is important. So, putting up a clothesline, putting up a laundry room next door to someone, but not actually preventing them from accessing the property, is not the kind of possession that is going to allow you to, what we say, defeat the title of a paper owner. So I'm going to talk a little bit more about what we call adverse possession next week. Today, I wanted to focus on generation property so that you could see how generations of us can have an interest and what I like to say, be beneficial owners of, so we have an interest, but we don't have an inheritance. We haven't received it. And this is how you can have multiple persons. So if your grandmother's, she died owning property and she had a paper title to the property, but no one ever probated her estate, then all of her descendants have an interest in that property. If your grandfather died or your great grandfather died, and he had a paper title, he had a conveyance, and someone can find amongst his papers where he had a conveyance, but no one ever probated his estate, then all of his descendants, if he had 3 children and 6 great grandchildren and 9 great-great-grands, or however many, all of those persons are entitled, have a claim to an interest in that property. And this is why I always stress to you the importance of making an application for probate for letters of administration and for making a will. So just to review, let's see. So with generation land, on claims to generation land, parties usually already co-own. So whether it's 2 of you or 4 of you, and maybe someone is living on the property and there's a question of a claim, you already have a claim, as opposed to, say, adjoining owners who are separate owners who are not related, and they are seeking to establish a claim to land that is adjacent to theirs. So generation property, someone already, or there are parties already have an interest. And if someone is living on the land and you have an interest, then your occupation, your possession of the land is already lawful. So for adverse possession, it really starts out kind of as a trespass. Okay, you didn't have any right to be on the land, but you went and you squatted on it and you stayed there for the 12 years that the law requires. That's a little bit different than what we are talking about today with generation land, where someone is on the land, using the land, occupying it, but they already have an interest, and so their presence on the land and their occupation, their possession of the land is lawful on that basis. They do have a legal claim. And so in this Miklwhite case, he wasn't really able to prove that he excluded anyone, because there was no one really to exclude. He was just on a portion of the land, and it's not like other relatives claim, his cousins or his aunt or uncle or second, third cousins came and he blocked them, and to the exclusion of all others remained in possession, or in this case also his daughter. And so the claim, the issue of inheritance is essential to his right to be on the property. So lawful as opposed to unlawful trespass. And then in that case, too, in the Miklwhite case, the court said that both parties would get a certificate of title because they both had an interest in the property. So it's not that one person got and then the other person didn't. And that is the distinction when it comes to generation property. So the moral of the story that I would say to you in this case is, please make the application for a grant of administration if you have a relative that has passed. Because what is going to have to happen is you have to go back. So your immediate past relative, you get letters of administration for that person's estate. And then once you have the grant for, let's say, your mother, then as your mother's personal representative, now you apply for a grant in your grandmother's estate. Or, if you're trying to deal with the property, then the lawyers are going to have to prepare an abstract of title showing how the chain of inheritance passes along in order to be able to do a conveyance of the property. So I know about a case this year where some relatives, and I think altogether there's probably about 10 persons cousins. It might even be more. So the grandmother, all of the descendants of the grandmother, who died, I think, in the 80s, and her estate was never probated. And all of these persons have an interest in that property. So they all have a claim to this piece of land, and nobody can deal with it. And I really hope that we can clean this up in the Bahamas, because as you could well imagine, that's why there are so many abandoned pieces of property, homes, lots, vacant land that it seems that nobody is tending to. So it's important. So take some time, and make the application. You'll have to consult a lawyer to help you with making the application for a grant of administration from the court. And then in your own case, if you have not yet made a will, then I would encourage you to have one made. And you can send me a message through my webpage at judgecarol.net and ask for a copy of my free will kit, which will help you to begin the process of making a will. So, you don't have to be scared. You don't have to be afraid. You don't have to be uncertain. And then, so you send me a note, get your free will kit, and then once you've completed it, you take it to a lawyer and have it drawn up in the according to the legal formalities. So, so at the end of the day, just to recap, in the Miklwhite case that we discussed, the petitioner in that case was already an heir. He was entitled to inherit from his ancestor, and his occupation was therefore presumed to be consistent with his own inherited interest, as he was not able to demonstrate that he intended to exclude the other heirs to the property. And that's why the court ended by saying that he and his relatives could get a certificate of title, because that case was brought under the Quieting Titles Act. So any person with a claim to land can ask the Supreme Court to investigate and declare who has the better title. That's what the Quieting Titles Act does. And in the Bahamas, there's no such thing as an absolute title. What the court looks for is who has the better claim. And that's why it does an investigation to see who has the better claim to the title, whether it's a documentary title or possessory title or a combination of both. So I think that's what I have for you today. We can go on, hopefully next week, we'll talk some more about adverse possession. And so final takeaways: if you are using family land, using it doesn't automatically make it yours, especially if you have acknowledged other relatives' interest. And if you're a family member but you're not living on the land, staying quiet doesn't mean that you've lost your share, but don't wait too long to assert your interest and claim, and keep some record of it. A letter, a conversation, a WhatsApp note, something like that, showing that you have never given up your claim to the generation property. And yes, family land situations are exactly why the Quieting Titles petition exists. It's the legal mechanism to finally settle whose land is this once and for all. So using land isn't the same as owning the land, but you've got to establish a claim and make your claim for the land. And if you don't have a will yet, again, I remind you to send an email to info@judgecarol.net and request your free copy of my will preparation kit. And if you have questions and you would like to have a private consultation with me, then also send an email to info@judgecarol.net, and I can send you the forms so that you can complete a request for a private 20-minute consultation with me. So thank you so much for being here today. Thanks to everyone who joined. And yes, so if you want to come and see me, please send an email to info@judgecarol.net. There's a consultation form, a waiver form, and the payment information form. I can send you all of that once you send me an email. So thanks to everyone for joining. And I'll be here next week for another live session of Ask Judge Carol. That's every Wednesday, 12:30 p.m., right here on my YouTube channel. So see you next time. Good day.